Appeals, First Appellate District of Ohio, with the Honorable Marilyn Zayas presiding, is now in session. Please be seated.
Good morning. I hope everyone had a great weekend. The weather was lovely, wasn't it? So today's Monday, August 29th. Welcome to the First District Court of Appeals. We have two cases on the docket. One is scheduled for argument this morning. The first case we have is case number C210518-620, State of Ohio versus Hammock, and that case has submitted on the briefs. The second case we have is case number C210655, State of Ohio versus Ward. Counsel, if you can please identify yourselves and your readiness to proceed.
David Hoffman for the appellant, ready to proceed, Your Honor.
Good morning.
Victoria Lowry for the appellee, City of Cincinnati, ready to proceed.
All righty. Attorney Hoffman, whenever you're ready.
Thank you.
Would you like to reserve time?
5 minutes for rebuttal, please.
All right.
May it please the court, Ms. Lowry. I'm here today representing Anthony Ward. He's appealing a conviction for complicity to theft. And to prove that Mr. Ward was guilty of complicity, the state had to show that he knew his passenger was going to steal from Mr. Dieters when he dropped him off. And if Mr. Ward was unaware that of the passenger's intention to steal, he could not be convicted of complicity.
Is it solely a subjective inquiry, or is it an objective and subjective? Or is it objective?
Subjective.
It's completely subjective, in your opinion.
The theft, I'm arguing that this theft was completed. You had a completed theft at the time these transmissions were loaded into the van. And by statute in Ohio, complicity has to involve aiding a person in the commission of the offense, not after the fact.
Well, but I mean, that's not necessarily accurate because you still had to get them off the property, right? And that's therein lies the value of the van is transporting them.
Well, that's true, and even the recycling was necessary too in order to get some money from them. But the theft, the actual theft, I think the asportation is the necessary element.
Yeah, but I mean, you've only moved them. I forget how far the distance was, but a couple dozen yards or something. You haven't got them off the property. Don't you need to get them off the property to ultimately complete the theft?
I don't think so, because the owner would consider it stolen at the time it's put inside that van. The door's closed, the engine starts. I think any police officer, I think there could even be a conviction for putting it in the van and preparing to leave with it. I think you'd have asportation.
I'm sorry. Mr. Hoffman, there's case law that says that complicity can be established by somebody driving a getaway car. Isn't that what he was doing? If we're looking at the facts most favorable towards the state, which we have to do to see if there's sufficient evidence, wouldn't that qualify?
Well, in those cases, in State versus Johnson, although the complicity has to be aiding in the actual commission of the offense, circumstances that take place after the commission of the offense can be circumstantial evidence of the intent to provide the aid. And so you're not really, after the theft is committed, then it's too late to be complicit.
But he drove him there. He drove him there.
Right.
And then he waited
Right.
until the transmissions were loaded into the car.
Right.
And then he drove him away.
Right.
So
to answer your
looking
question,
at the facts, again, most favorably towards the state, which we have to do to consider whether there's sufficient evidence, wouldn't that be enough to show complicity?
Well, no, because in the bank robbery illustrations, you're being a wheelman to escape a bank robbery with the alarms going off, people going there. I mean, there's going to be evidence of a knowledge of their intent to commit a bank robbery. There's going to be evidence that you knew before you dropped them off that they were going to commit based upon what happened after the robbery. But still, the key is what...
But I mean, there's plenty of cases where the driver is like, oh, I had no idea they were going to go rob the bank. I thought they were going to go make a deposit. And the next thing they come out and they jump in the car and say, go. But the judge or jury is free to disbelieve that, right? And to say, no, you knew that that's what was going on.
That's true. That's true. The finder of fact
Right.
can reject that.
Right. And so, like, then bringing it back to the facts of this case, this guy says, I was a bootleg cab driver, and, if the fact finder rejects that and does not believe that, then, how is this not appropriate evidence to convict him on?
Well, first, from a sufficiency standpoint, I still think it's important to look at whether there's proof that my client knew of the passenger's intent to steal at the time he dropped him off. And I think there's no evidence of that, even after the fact. If you would superimpose my client's conduct into a different situation where a person acted perfectly legally, it wouldn't be suspicious at all. I mean, he provided a ride to someone to a place and drove him away. He never got out of the van. He had a fare, and that's all he did. If it were a yellow cab with all the markings on the car and the driver was licensed, I don't even think we'd be having this discussion. The fact that he was a bootleg made him so unofficial, I guess, or something, that it just, in the eyes of the authorities, it just made him suspicious, and
So
and he was
basically,
charged
is your
for that.
argument is that the act itself is not sufficient to establish the circumstances for the intent?
Yes. If you go by the cases that say that mere presence is not enough, the reason for that rule is that you have to have some evidence that the
Well, this
person
is more than mere presence. So when I say the act itself, it's the act of taking this individual to the garage and then driving them to the scrapyard. So what you're saying is, which is the basis of the aiding and abetting, right?
Yes.
So what you're saying is those acts that go towards the aiding and abetting, that alone cannot be sufficient to develop the circumstantial evidence from which one can draw the intent.
Yes, but I'd like to just suggest that the actual actions that would make my client guilty would have to be limited to driving him to the place. I think after driving him away from there, taking him to the scrapyard is after the fact. I think the complicity would have to be in the commission of the offense, and that would be the removal of the transmissions, and not necessarily the processing of them after the fact. One other thing
Doesn't that go more to when did the complicity occur?
Right.
There could be a 10 series of events, and the first one establishes the complicity, and the other 9 just further establish it, right?
or have circumstantial evidence of the defendant's knowledge. I think that would be the proper use of those other instances. But anyway,
So it's your position, again, is that besides the acts that go to complicity, that there wasn't anything further to establish that could be used to establish intent?
that's correct.
Right. And there was no testimony other than your client's with regard of direct evidence of intent?
There is a little bit of relevant evidence that I uncovered on page 79 of the transcript.
Okay.
When the officer testified to my client being unable to accurately talk about the scrapyard, the officer testified that my client mentioned 3 other scrapyards that he had visited, not necessarily on the same day, but that couldn't be verified as the proper scrapyards because of the inability to identify the passenger.
Now, who's he visited? Who's the he?
Oh, sorry. The officer couldn't verify that those scrapyards were the scrapyards that my client visited with the passenger on the day in
Okay.
question. But it suggests that my client goes to scrapyards, and And you know how you have dumpster divers, people that legally get trash and recycle things. Well, some of those people may need transportation to recycling. And so I suspect that my client might do this from time to time. And so based upon what the officer said. And so I think that
Well, that's a lot of inferences, isn't it?
it is, but he did mention three scrap yards in addition to the one he mentioned.
Okay.
That he had
So let's
gone
go
to.
back, let's get back to intent. With regard to intent, Judge Bergeron asked you with regard to a determination of credibility by the trier of fact. So is it your position that your client said, hey, this is what my passenger told me, this is what he was doing, which is inconsistent with the theft, right? That he actually had consent to pick up these transmissions. So are you saying that it's not enough for the finder of fact to not find your client to be credible?
Sorry, I had too many knots in it for me to get it.
Okay, so with regard to intent, your client testified that there was consent, that he understood there to be consent.
Correct.
There was a determination on credibility. Would you agree from the finder of fact?
Correct.
Okay, so how does that go into the calculus of intent?
Well, I'm arguing that the fact finder lost their way. I'm saying that there was evidence of credibility that might not have been considered by the fact finder, and that the credibility determination can be reviewed by this court, and although the finder of fact is in the best position to see the demeanor of witnesses, this court has the transcript available with the facts, and it has a duty to re-examine credibility every time you get a manifest weight claim. And so I'm asking the court to do it in this instance and find that the evidence that my client knew beforehand that this theft was going to take place, there wasn't any.
What would you point to the record that as to what would be inconsistent with with the finder of fact determined on credibility?
His candor with the police, for one thing. My client was very candid with the police. He even detailed the fact of the payment, and the source of the payment for his fare was going to come from the recycling. I mean, that was potentially incriminating, but he said it anyway because it was the truth. Mm-hmm. And I think it also suggests that it's not the first time that he's done this. That fact, and also the fact that he has visited recycling yards, I think it suggests that he does this from time to time, and he relies upon people telling him that the items that are being recycled are not stolen. So that's something.
So unless there's any other questions, if you'd like a few seconds to wrap up.
Yes, I'd ask that this court would reverse and remand for not just a manifest weight claim, but I think on the basis of sufficiency, because of the limited test that has to be applied to determine complicity and its involvement with the commission of the offense and not after the fact. So if there are no further questions, I ask that the court would reverse. Thank you.
Good morning.
Your Honors. Good morning. May it please the court. Victoria Lowry. So, the Honorable Judge Mike Peck convicted Anthony Ward of complicity to theft. He was the fact finder in this case, and the state presented evidence to him that was sufficient for that finding of guilt, and the finding was not against the manifest weight. The evidence that he was given included testimony from Mr. Terrence Dieters, who was credible, reliable, certain that this was his private property, that he had not given anyone permission to take it. He testified to the surveillance video that identified the vehicle that drove onto his property, which led us to Anthony Ward. In fact, when the police went to Anthony Ward, Mr. Ward admitted to having been the driver that day on the property when the property was stolen. Mr. Ward was shown not to be the one that got out of the vehicle, who took the stuff. So he was the driver. He was sitting in the car. He never left the car.
I mean, isn't the main issue here intent?
Yes, so I do agree that the intent, the culpability to steal the goods is the issue that the court had to find. And the fact finder was,
Would you agree that it can be determined from circumstantial evidence?
yes, circumstantial evidence
So-
is just as good as direct evidence.
So where in the record, what parts of the record would you point to that would support that?
In the record, we have that Mr. Ward drove the car, so he was assisting with the theft. It also was shown that he was cooperative about the theft because he agreed to a lesser payment when the theft offense didn't result in as much profit. His inability or unwillingness to identify anything about the person that was with him that day. And
Does it matter if he knows the identity?
well, I shouldn't suggest that his silence on any issue is in any way a factor for the fact finder to consider. But he did tell the state, through the police, quite a lot about what had happened. But it was all very vague and non-precise in such a way that it was actually incredible, which is a factor if we're considering evidence in favor of conviction. But
How much time was there between the time when the transmissions were stolen to when the police apprehended him?
I'm sorry, it's not hard and fast in my mind, but I want to say it was about a week that the police did some investigating and then were able to identify the license plates and then went out to Mr. Ward's home where they spoke to him at his home about the incident.
Did they get access to his phone to try to ascertain who the
Not that I'm aware of, no.
Well, I know they took his phone. I remember seeing that in the video, but I wasn't sure if they looked into it.
They didn't get any identification of
What if the facts were changed a little bit and rather than a transmission, it was like a briefcase, which doesn't seem as, there's a briefcase sitting on the porch. He goes up, gets the briefcase, comes back, and the video showed that the driver sitting there on his phone the whole time, oblivious to what's going on. So really, he has no idea potentially whether the guy went to say hi to somebody, whether the guy was dropping something off. Guy walks back in with the briefcase. He drives off. Like, is that enough? Would that be enough to convict him? If the briefcase was stolen, and would that be enough to convict the driver of complicity?
with just that limited amount of facts, I do believe that a reasonable fact, but that's not my decision. That would be your decision, whether those facts are sufficient to have convicted. And I do believe, though, that a fact finder is in the best position to evaluate that evidence and determine under the entirety of what's been presented to him whether or not this person knew at the time when he was sitting there waiting for the person to leave and go up and get the briefcase. In this situation, I think I was asked, and I didn't quite get to the point, was
Yeah, I want you to get back to what is the circumstantial evidence that you would say that
I believe that the
establishes
court
the intent?
looked at the unreasonableness of the story that Mr. Ward told was something that the court had to consider, because there was testimony from Mr. Ward that he, and his reports to the police, so testimony from the police as well, from their interview of him, that he just met this person at a party and that then he randomly saw him on a street corner, and he didn't ask any questions about who he was or where they were going, but he agreed to some fee for driving. That is more incredible than what the fact finder could have believed, was that we are going to go onto this private property and we're going to take these transmissions, which are conveniently located outside of a garage because the garage has been opened up by a car crash, and we're going to take them and exchange them for not the value of transmissions, but the value of the weight of the metal. And we're going to go onto that property, which is clearly marked as private property. It's a business and a home. And we're coming from outside of these premises with no reason to think that we actually belong there.
What do we do with, one of the arguments in the appellant's brief is that the video shows the person, the passenger, get out of the vehicle, go get the transmissions with no seeming concern, not looking over his shoulder or anything of that nature.
That is true. I acknowledge that the fact finder did see the same video, that the person is moving sort of slowly and not furtively.
And in broad daylight.
And in broad daylight, but there are no other people around. In fact, those people I can't suggest what that thief knew about where those people were, but they were all gone. There were no people on that property at that time, so there was no one to be concerned about catching them. And, of course, the vehicle was right there with a driver in it, ready to flee at any moment if such a thing could have occurred.
Would this be different if Mr. Ward were, as Mr. Hoffman suggested, driving a yellow cab, a registered yellow cab? Would this be a different situation? Or even if he was an Uber driver, a registered Uber driver?
I don't know whether the police took that into consideration, but I don't believe that the court was asked to take that into consideration, whether this is a guy who drives his friends around, a guy who considers him a bootleg cab, or if it was an Uber driver or a taxi cab. If a person knowingly is using that vehicle to commit a theft offense, I don't think the court considered whether he was also committing a crime by having a bootleg cab. I don't think that was an issue for the fact finder. It never really got mentioned by anyone except the defendant to explain away the complicity. I'll move on to, I'm happy to be directed. So, as to the sufficiency of the evidence, I know the court is already aware, and I concede that this is a de novo review, but it is not the appellate court's position to reevaluate how they would have interpreted the facts that were presented to the fact finder, but just to only find if there was enough evidence for the fact finder, if he were reasonable, to have found guilt beyond a reasonable doubt. But I'll move to the manifest weight, because I did think there was a point to be made about the reviewing court is reviewing all of the evidence again. But I believe it's the appellate court's position to find out if any of the evidence that was in favor of the state's conviction, if that was incredible or unreliable or uncertain. And the state presented not only the evidence from Terrence Dieters as to the theft itself, and the video that showed that Mr. Ward was there driving the car, so assisting, but the state also presented evidence from the officer, which was again, not incredible, not unreliable, or not uncertain, that his investigation led him straight to Mr. Ward, and there was an admission by Mr. Ward that he was the driver of the car during that theft offense.
Well, there's not any question about the identity of who was driving. It's more about whether it's about his knowledge. Correct?
Yes. And so if we're weighing the evidence, then we say that the fact finder also had to, and you would also have to consider whether or not the evidence against conviction, which was the testimony of Mr. Ward that he didn't know what was going on, that if you think that it was uncontroverted, unreliable, or uncertain, that would change the way you could evaluate what the judge, how he weighed it.
Was the body-worn camera footage, that was shown during the trial, correct?
Was the body-worn camera shown during the trial?
The body-worn camera footage, where the
Yeah.
officer, when he arrested Mr. Ward, and the exchange that they had at that time, was that viewed by the trial court?
I apologize that I'm not remembering exactly. I know that we watched surveillance video. I remember reading about it as well, but the surveillance video from the property owner. I don't remember, I'm sorry.
Okay.
I'm not very helpful that way. I do know that the officer testified to the same, though.
Okay.
On the interview. So if the fact finder found that what Mr. Ward said was incredible and therefore unbelievable, or some or all of what Mr. Ward said, because I am arguing, using Mr. Ward's own words against him, so the fact finder can believe some of what Mr. Ward said and not believe other things that he said. And if the fact finder were to find that he believed that he drives a bootleg cab, and he believes that he took $10 instead of $20 for the cab fare because the theft offense didn't result in as much profit as they believed it would. But then he can also not believe that he didn't know who this person was, or that he just picked him up on a random street corner and doesn't know where that was. He dropped him off somewhere else and he doesn't know where that was. And he doesn't remember where he took the transmissions to exchange them for such an insubstantial amount of money that he only made $10 for his cab fare. The fact finder can do all of that reasonably and not be against the manifest weight of the evidence. And so therefore, I would ask this court to affirm the conviction. But if you have,
Thank you.
thank you.
Please, the court, I think Ms. Lowry touched on something that might have been important to the finder of fact, and that is my client's inability to recollect where he picked the passenger up, dropped him off, and which scrapyard he went to. And I think that there might be an explanation for that. And that is that it's a principle, a known fact, that unfinished tasks are remembered a lot more than finished tasks. As a matter of fact, it was a startling discovery. A person named Zygarnik studied this and found out that people that, it was in the context of people that wait on tables. They had a great ability to remember what people ordered and what change was due even. And it was a memory, a retention that was just phenomenal. But after they had finished with that table, it was just the opposite. They couldn't remember a thing about it. And it's a known fact. You can Google it. It's Zygarnik is the guy's name, and he did a study and proved it scientifically that it happens. And so if my client is a bootleg cab driver, and they did arrest him at the time he was giving somebody else a ride, and if he's conscientious about it, he might have a lot of clients, and it might be difficult after the fact to recollect the details of it. I think he was questioned not long, within days after this event, but the arrest was a month later, but I think the interview was soon thereafter. But it doesn't change things because those waitresses and waiters, I mean, they lost their memory immediately almost. And so it's explainable is all I'm saying. It doesn't necessarily mean that the guy did it. So if there are no further questions, I would ask that this court would reverse. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a great afternoon.
All rise. The Court of Appeals First Appellate District, Edward House, is now adjourned.
We off the record?